This is Andrew Branca. He wrote the book on self-defense. He's considered a national expert in the area of self-defense, and he was recently on Tim Pool's show. This was about Dominick Black and whether Dominick was legally allowed to go ahead and let Kyle Rittenhouse possess that rifle. If you remember, Kyle was originally arrested for possessing a weapon under the age of 18. That charge was dismissed, and therefore everyone is saying that, well, the charge against Dominick Black should be dismissed as well, and I agree. So what's the hubbub? Well, Andrew Branca is going to approach this problem. He's going to reach in the depths of his experience, and he's going to screw up. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dread Show.
All right. Tim Pool, he had Andrew Branca on his show, and he's going to talk about Dominick Black. Let's listen in. And yeah, by the way, Tim Pool's a big jerk.
He's going for Dominick Black on the gun charges, but I think he's desperately trying to get back at Rittenhouse. Because I think the gun charge was dismissed, right?
Yes.
The other charges were dismissed with prejudice.
On Kyle, not on
Kyle.
On Dominick.
The judge said
that case is still up.
Count 6 is dismissed. On the all other charges, he was acquitted on. So I guess the argument...
gun charge is not coming back against Kyle. That's not going to happen.
You don't think it's possible?
No.
I don't trust Binger.
It's not realistic. Basically, the judge ruled as a matter of law, it doesn't apply. So you don't get to just go shopping for a different judge.
But here's my question, though. In Dominick Black's case, they actually get another judge to say, oh, yeah, that's a misreading of the law.
It's two different statutes. They're not charged under the same statute.
That much is true. They are not being charged under the same statute.
But here's my question about that. They're two different things. So the statute they charged Kyle with simply is inapplicable to his circumstances. I've done a lot of analysis on this. It's too late.
You've done a lot of analysis on this, huh? Well, you probably should have done a little bit more.
To get into. But that statute is a completely different statute than Dominick Black is charged under. So the fact that Kyle's was dismissed has nothing to do with Black's, and Black's has nothing to do with Kyle's.
Yeah, wrong. Golly, how could you screw this thing up? Let's take a look at the statutes. I know you don't believe me. We all know 948.60 intimately. We have covered it numerous times on this show. So let's take a look at the statutes in question. We have Section 2, subsection A. Any person under 18 years of age who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor. That's Kyle. Subsection B says, except as provided in paragraph C, any person who intentionally sells, loans, or gives a dangerous weapon to a person under 18 years of age is guilty of a Class I felony. And by the way, I call these subsections, actually they're called paragraphs, whatever. But notice something, they are different. This one here, subsection B or paragraph B, is for Dominick. So Andrew Branca is right. They are being charged under completely different statutes. Where did he screw up? Well, he made a claim that whatever exception allowed Kyle to possess that weapon has no bearing on Dominick Black. False. Take a look. We go to Section 3 and Part C, or Paragraph C. This section applies only to a person under 18 years of age who possesses or is armed with a rifle or a shotgun if the person is in violation of Sections 941.28 or is not in compliance with subsections 29304 and 29593. And of course, this was the major deal concerning the gun charge that Judge Schroeder had to deal with. And this concerned the length of the barrel and the length of the rifle and the hunting accomplishment degree of certificate or whatever you want to call it. There was a whole tangled mess in there. We all decided early on that Kyle was legally allowed to possess the rifle. Of course, the anti-Kyles came out there with their dumbassery and said, well, what about the overriding statute up above? Yeah, who cares? This is called an exception. Now, they'll never understand that. But whatever the case, we all went over this thoroughly. I have 4, maybe 5 videos on this subsection here explaining everything. Now, this is Kyle. According to these exceptions, Kyle can legally possess the rifle. The question now is, can Dominick allow Kyle to possess his rifle? Well, ordinarily, no. Why? Again, let's go back. Except as provided in paragraph C, any person who intentionally sells, loans, or gives a dangerous weapon to a person under 18 years of age is guilty of a Class I felony. Okay? Now, where is the exception to that one? Well, guess what? It's in the same subsection or paragraph as the one dealing with Kyle. It states, this section applies only to an adult, that's Dominick, who transfers a firearm to a person under 18 years of age, Kyle, if the person under 18 years of age is, guess what, not in compliance with subsections 29304 and 29.593, or to an adult who's in violation of section 941.28. Well, he didn't give the rifle to an adult, so that's not an issue. 29.304 and 29.593 are what? The same statutes that allowed Kyle to possess the rifle. So in other words, if Kyle can possess the rifle, Dominick Black can allow him to possess the rifle. It's right there, Andrew, right in front of you. How did you miss this? Let's go back and play some more of this.
That being said, the killings do apply.
It might. I mean, if I were Black's defense lawyer, I would start arguing that, look, the statute...
A gun that was used in a death.
Right. So
that
giving a
resulted
gun
in
to a
death.
minor and a death results.
Yes.
And it's intended, of course, to prevent giving guns to young gang members who then go kill people or get killed themselves. And obviously nobody wants that. But in those cases, what the statute's intended to prevent is unlawful deaths. And that didn't happen here. This gun was used in a justified manner.
He's correct about that. Even if the judge rules that Dominick Black is liable for the extra deaths that resulted from Dominick giving Kyle the rifle, an appeals court would certainly overturn it. The precedents that would be set by convicting Dominick under such circumstances would be completely intolerable. After all, one could say that the rifle saved a life. So do you add on a 6-year penalty for allowing somebody to have a weapon that saved his life? Keep in mind, Kyle Rittenhouse was acquitted. And why? Self-defense. So an appeals court would almost certainly side with Dominick Black on that. So is there any concern about the fact that the rifle was used to shoot somebody or even kill somebody? And they're debating it. It's like, well, I don't know, maybe the judge might rule this, maybe he might rule that. Come on, guys, go back and read the damn statutes. Look at paragraph C. It states, whoever violates paragraph B is guilty of a Class H felony if the person under 18 years of age under paragraph B discharges the firearm and the discharge causes death to himself, herself, or another. However, go down. It states, this section only applies to an adult, blah, blah, blah. So if Kyle can be found to not be in violation with these substatutes, then he is certainly not in violation of paragraph B. And because he's not in violation of paragraph B, he can't be held in violation of paragraph C, because paragraph C starts with whoever violates paragraph B. Oh my God. Come on, guys. Get with the program. You have 3 people on that show, and not a single one of you bothered to read the damn statutes. Come on. Like my videos, subscribe to my channel.